सेवन लैम्प्स ऑफ एडवोकेसी। अगर लास्ट 3 वीडियोस आपने नहीं देखी तो प्लीज़ इस टॉपिक को लेके 3 वीडियोस ज़रूर देखना। सेवन लैम्प्स ऑफ एडवोकेसी क्या है? इसका निमोनिक है HCJ वाइफ। H for honesty, fiduciary duty to act in the best interest of their client. Such honesty should be reflected in every single act of theirs. Viz, while delivering the argument, thoughts, words, so on. Courage should remain fearless under pressure and pain. Judgment, ascertain facts, merit, demerits, counter argument, tackling with intellectual capacity. Wit means capacity to think clearly and speak concisely with an ingenious expression of thoughts. Industry, acquainted with the latest law. Fellowship, obviously oppose the other to uphold the interest of their client, not bother the friendly relationship. Not मतलब it should not bother the friendly relationship. Opponents, it should he should take the other party as if opponent, not as enemy. Eloquence is the art of speaking. In fact, the it is a panacea of for all the incompetence. So we should say that it is the most important lamp of advocacy. And eighth lamp was introduced by V. Krishna Swami Iyer in the book name Professional Conduct and Advocacy. Importance of legal profession of India. So the legal professional which was evolved into a more professional and more um, uh, justice to the administration, administrative justice. It plays a very pivotal role in the country and around the world as an advisor, upholder of the right of the common people, and as a professional. First of all, uh, legal profession is important because it helps in solving dispute between the parties, various entities like two individuals, between the governments, between the government and the common people, or any other matter. They advise their client on the right path and legal remedy to take. At the same time, help in achieving that remedy in the courts of law. Of course, they charge their clients for this, but monetary benefit is necessary for sustenance and survival of any profession. Second, the lawyer help the common people in upholding their basic rights. They do this with the help of public interest litigation, that is PIL, through pro bono litigation or other forms of litigation. They help in preserving the grand norm, that is the basic or fundamental part of the law, that is constitution. They also help in maintaining the balance between the legislation, executive, and judiciary bodies. Thus, the legal profession is fundamentally important for administration of justice in the country through various means. So, next topic is right to pre-audience. So, it is just a right to be heard over the others. So, it means that shall the person should have the prejudice over all other advocates. So suppose this is a serial number. So first is Attorney General of India. The Attorney General of India have pre-audience over all other advocates. Then Solicitor General, then Additional Solicitor General, then second Additional Solicitor General of India, then Advocate General of State, any state, and it should be noted that Advocate General inter se shall be determined by their respective seniority. Seniority advocates shall have pre-audience over the other advocates and determined by their respective seniority. Then coming to the senior advocate. Who is senior advocate? So, senior advocate, it's a term. It is term or recognition provided by the Supreme Court or High Court of India when they are is of opinion that the virtue of his as stands for ability, standing at the bar, or special experience or knowledge in law. He is deserving of such distinction, and there should be some it is subject to such a restriction as the Bar Council of India impose. Then what are the restriction on senior advocates by Bar Council of India? Then they should not file a wakalatnama. They shall not appear without an advocate. They be free to make connection or give undertaking in the course of argument. They should not accept directly from a client any brief or instruction to appear in any court or tribunal. They should charge reasonable fee if they are elected under the Part 2 of the state rule. Then next topic is complaint procedure against the advocate. So suppose an advocate breached something, or his conduct is not professional. So what the person should do? So it is a this is a procedure against the advocate if anyone files a complaints against them. So coming to this, first point is that a complainant a complaint against an advocate should be filed. The mode of petition, the mode through which this complaint should be filed is the petition. So it should be signed and verified under the CPC, and it can be of any language. Then the secretary of the BCI may require the complainant to pay the prescribed fee if he has not paid it, and cater to any defects or attach proper document particulars required in this complaint, and it should be registered and placed before the Bar Council of India. Then third point is complaint can be dropped, withdrawn, settled, and complainant if the complainant does not want to proceed with the inquiry. And fourth point is bar council refer complaint to the disciplinary committee, then by through notice E1 E2 to advocate, and request to submit the statement of defense. Then fifth point is chairman of disciplinary committee will fix date, time, and venue of inquiry within 30 days. Then the both the parties, complainant and the advocate, should appear for hearing. Then seventh point is the discipline committee, after giving advocate concerned and therefore the advocate general a chance of being heard, may make any subsequent order, namely. So मोटा मोटी इसमें चार ही ऑर्डर होते हैं. पहला होता है डिसमिस द कंप्लेंट, कि डिसमिस ही कंप्लेंट कर देना. इफ़ द प्रोसीडिंग्स वेर इनिशिएटेड बिफोर द स्टेट बार काउंसिल, then they can direct the state bar council to proceed with the filing. Then they can reprimand the advocate, they can suspend the advocate from practice of such period as it deem fit, and remove the name of advocate from the state rule of advocate. So that are the four actions that can be taken by disciplinary committee. So against this decision, against this proceedings, appeal can be filed. Appeal can be filed by the advocate over the order of the disciplinary committee. So here the aggrieved party will be the advocate. Then coming to the next point 38, that is all India bar examination. So all India bar examination is responsible for conducting examination by Bar Council of India for law graduates who are willing to start practice or of lawyers. So once they appear for the examination, then candidate will be awarded certificate of practice after clearing the examination. And once they get this certificate of practice, they will be or they will be eligible to practice in any court of India. Then coming to the next point, qualities of an efficient and successful lawyer. So the mnemonic for this is GDP Carwali. So GDPPCCARWAL. GDP Carwali. So G stands for good judgment, good decision making, or good communications. Then D stands for decision making skills. P stands for perseverance. Then problem solving. Then C stands for comprehensive skills. Another C stands for compassion, that is the emotion balance. Then A stands for analytical skill and logical thinking ability. R stands for research skills. W stands for writing and drafting skills. Stands for attention to details. L stands for listening skill. So these are the qualities of an efficient and successful lawyer. What is bar? So bar stands for State Bar Council. Bar. Let's hear this. This is not the State Bar Council. So what is bar? This is a fresh topic that we are going to discuss. So advocates who are registered by the State Bar Council after receiving a degree of LLB from the university and receiving a specific amount of training under the supervision of advocate as stipulated by the rules. Uh, those advocates are collectively referred to as bar. A advocate is designated as a representative of the bar. For the most part, the term bar refers to an association of attorneys who are licensed to practice in the courts or specific courts or of any state. Then what is bench? The bench, the judges are collectively referred to as bench. The term bench also refers to the key component of the court deemed in its official capacity while the judges are sitting. The term bar was originally used to refer to the part of the court that dealt with attorneys. However, the term is now used to refer the part of the court that deals with judicial officer, which is known as the bench. Now, we should understand what is the relationship between the bar and the bench. They are the two wheels of chariot. Chariot means rath that plays a role in administrating the law, administration of justice. Both the subordinate to each other, interrelated to each other in their respective roles. They pertains to the friendly relationship that advocates have with judges. The bar and bench are two opposite sides of the same coin, as the saying goes. The administration of justice cannot be successful unless there is unity between the bar and the bench. An advocate scandalizing of court is truly despoiling the very foundation of justice, and such behavior by an advocate tends to bring dishonor to the entire administration of justice. Therefore, the behavior of an advocate towards the court is always one of uniform reverence, regardless of the status of the court in which the case is being heard. The advocate personal view of the judge must not be shown in his conduct because he has responsibility to maintain the respect of the judiciary as a professional organization. At the same time, it is a responsibility of judiciary not only to be courteous to member of the bar but also to do everything in their power to progress and high traditions of the profession. Therefore, the contempt of court can be imposed on a lawyer as well as on judge for their discourteous behavior or misbehavior. Then coming to the role of bar to strengthen the bar bench relationship. So as we know, bar means the collective body of advocates. So advocates like judges plays a significant role in administration of justice, and advocate has to practice the following steps to preserve and maintain the relationship between the bar and bench. So he should show reverence. Reverence means respect to the judges. He should assist the judges, not displease the judges. Judge Judges should not be criticized for the wrong decision. An appeal can be filed against them, but not they should not be criticized. They should not exert stress or control on the judges. Judges' conduct is sometimes we saw that judges' conduct is annoying and disrespectful to the advocate. But the advocate should not indulge in cross argumenting it. He should refrain from engaging in violent talks. So the formal way of doing that is that the issue should be addressed with the judge in the chamber, and the bar association should make a formal request that the misbehavior should not be repeated, and they should be constrained and avoid from engaging the unfair practices or practices of doing the law practice. Then coming to the role of bench in strengthening the bar bench relationship, as we know that bench has enormous power than any power provided by the any provided to the government or the military. A judge has to practice the following steps to preserve and strengthen the relationship between the bar and bench. Judges should respect the advocate. They should act and approach the case with the fair, open mind and without bias or prejudice. Judges should refrain from interfering the lawyer, interviews of witness, presentation of the arguments. In most cases, a judgment intervention is confined to the following factor like avoiding reiteration and time wasting, avoid providing clarification, sharing an opinion of the court on a particular point, and promoting the expeditious disposing of the case. So, as we know that a bench act as a decipher the rules, the laws, rule, directive, regulation, codes, bylaws, circular notice, and other documents. So it plays a true significance of the statute, and there should be a proper explanation to it. So they should not be there should be a adequacy of adjournment should be there. Justice deferred is justice denied, so there should be a proper check on the time also. They should refrain from making unjustified public remark about a lawyer lack of legal insight in open court. They should have duty of ensuring and preserving judicial independence. Judge's moral responsibility and honesty should be unquestionable. Judge knowledge should be kept up to date with the most recent advancement and transformation on legislation. And briefing of judges and advocates are scheduled at regular intervals to strengthen the relationship between the bar and bench. During these sessions, the problems of the opposing sides can be discussed and the differences can be resolved through discussion. Then we can see there are few committees under this act, that is section 10. So constitutional committee other than disciplinary committee was discussed under section 10. So section 10 says that a state bar um, council can constitute the following committees. These committees are executive committee and enrollment committee. Committee have five elected members of the council amongst its member. The enrollment member contains three elected members. Similarly, the Bar Council of India shall constitute the following standing committee. Namely, the first is similar to the State Bar Council, that is executive committee. An executive committee in under the Bar Council of India have nine elected members uh, uh, of the nine elected members by the council from amongst its member. And a legal education committee should have 10 member, जिसमें से 5 elected members of the council and 5 co-opted which was not elected by